following the recent judgments of the Federal High Court sentencing the leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, to life imprisonment, was in Nigerians, including lawyers, debates the dynamics around this long drawn-out litigation, including the outcome. As it stands today, it has become not just a legal debate, it has also formed some sort of political and social basis for dialogue amongst citizens. What exactly were the elements, or if you like, the legal ingredients in this particular case that made it so spectacular in a manner of speaking? As it stands today, for example, we hear that there are those who still see a window of opportunity within the ambits of appeal for these judgments to be overturned. In fact, there are those who believe very vehemently that a political solution is still possible as it stands today. We'll find out in the course of our conversation on the program of this week, but that will be right after this break. As always, it's a delight to welcome you to Scale of Justice here on Global Television. I am Uyi Agmofwebe. My guest today is a legal practitioner, and he'll help us understand exactly what led to the outcome of this particular case. I'm joined by Barrister Monday Eje to help us find context and beat this conversation into perspective for us. Thank you so very much for taking our time to join us on the program.
Thank you for having me.
Great. So I'd like us to look at what made this case so complicated in such a way that it just became spectacular, something that some people say, well, it could have been resolved without even having to go to court in the first instance.
Okay, well, a lot of things actually make the case spectacular. I think the first thing is with respect to the individual involved, Nnamdi Kanu, and the agitations he's been involved in. The fact that that agitation also has to do with a particular people, and you know, his antecedents with respect to the way he went about the agitations. All of this put together actually gave that case the notoriety it got, because number one, it has to do with certain political motives, because the agitation itself has a political coloration and went on to begin to have some economic impact on the region, and by virtue of that, the country as a whole. And then we had rumors of killings, alleged killings, that have now been adjudged to have actually been carried out by IPOB. Then the drama that has to do with the bail terms, bail conditions, the appeals in that regard, the issues surrounding the objections or preliminary objections that were raised. You know, that one too had to move up to the Court of Appeal, Supreme Court and back, and eventually issues of jurisdiction that was raised in the course of the trial. The issue as to whether the act under which he was charged and sentenced, whether it was in existence, whether it ought to have been charged under the act, and so on. So, and most importantly, what got it most dramatic is the fact that the people involved in the trial, Nnamdi Kanu himself, his allies, sometimes the lawyers involved, choose to, you know, take the trial to the social media. The drama around it, the show raised angle around all of this made it such that it cannot be ignored. And you know, the fact that it involves a particular people and the representative of those people, the elder statesmen, the politicians, and one or two of them going back and forth, getting themselves involved with some talks with the presidency at some point in time. And when he even eventually, at the time he got bail, the fact that it was a senator that also shorted him at that time, all of this gives it so much weight that you can't be in this country, even outside the shores of this country, and say nothing is actually happening. So these are a combination of factors that have made a simple, what ought to be a simple, normal criminal trial be complex, complicated, and an abnormal trial of some sort. So, but at the end of the day, we are where we are with respect to the outcome of the judgment. And like you stated in your introduction, some people have felt that, some people feel that, there's a window of opportunity for him with respect to appeal. And some said, this issue cannot be basically sorted out through the legal procedure alone. Political conversations have to, be involved. So from both lawyers and, laymen, we've had these common views. But I think most disturbing is the fact that many people have taken to analyzing this case without having an idea of what the facts of the case are, without also having taken a look at what the judgment is, the reasoning of the court with respect to the issues raised in the trial, what his views are, is what gives us lawyers concern. That is not to say some of us lawyers did not actually told that part. We did. I understand that the judgment is about 144 pages judgment, and then some people have problem reading all of that.
Quite extensive.
Quite extensive. But you see, to be able to comment and then stand your ground with respect to that judgment, it's the basic thing to do. Read the judgment. I've done that like 2 times. The 3rd time I didn't finish it, which was the first time I actually decided to read it. And you see, the issues are many, so you won't even blame those who didn't read it. But suffice to say that the first thing people, started doing with respect to this trial was when Simon Ekpa's case was decided, and the first issue was why is Kanu's case taking several years when Simon Ekpa's own was, I think, barely 6 months or thereabouts. And I've told friends, I've told colleagues, and I said, look, the Nnamdi Kanu's trial is not a trial that ought to have taken so much time. Why did I say so? You have one individual who has been charged for terrorism, acts of terrorism. And then you have the police, just 2 parties. And all they needed to do was to put in their evidence, and they get cross-examined, and Nnamdi Kanu puts in his own defense, and he also gets cross-examined. But we were faced with a situation where you will have a judge commence trial, and then you have the defense raising issues of bias. So the first judge was out. The second judge was petitioned. They petitioned the CJ with respect to the second judge, and the judge said, okay, fine, since you've brought up a petition against me, I recuse myself.
That probably was Justice Yanko, I suppose.
Yanko was the third.
The third.
The third. And at the time, Justice Binta Yanko was being accused of bias and asked to recuse herself. The matter had gone far. The prosecution had closed their case. The defense raised a no-case submission. And out of the 15 charges at the time, 8 were dropped. At that time also, there was this issue of whether it can be tried under that law, and whether or not his rendition was proper, and whether or not that rendition, which was extrajudicial, should not be taken into consideration in the trial. So we had the Court of Appeal at that time, saying no, the trial court cannot ordinarily proceed to trial and would have been divested of jurisdiction because the manner in which it was wrongfully, unlawfully brought in from Kenya
into Nigeria
to face the trial had robbed the court of jurisdiction because that extrajudicial rendition was against international laws and our own state laws. So the prosecution proceeded, they went to the Supreme Court, and the Supreme Court looked at the situation. I think about 3-4 cases from the United States were referred to, and eventually the court also looked at our own case laws and said, look, based on the case laws we even have in our country, we've established sufficiently over the years that once a court has jurisdiction, the manner in which that party is brought in before the court for trial should not affect the jurisdiction of the court. Jurisdiction basically is two wings. We have the procedural jurisdictional issues, which can actually, which are issues that border on irregularity of procedures,
right,
and which in law generally can actually be waived, except the party involved does not want to waive it, and then he or she will raise it up at the earliest possible time for the court to strike out the charge, not to dismiss. In this case, not to discharge or acquit. What the court will do, if you succeed with a procedural issue, is basically to strike out the case. The procedure will now be corrected, and then you'll be brought back. So
the case starts de novo, is that the point?
Yes, so the case now starts de novo after parties would have, or the party in default would have corrected the procedure. Now the other angle to jurisdiction is the substantive jurisdiction. Now this one is the one that is vested by the statutes. Statutory jurisdiction is vested by the statutes. And when the law vests jurisdiction, even parties cannot by agreement divest the courts of jurisdiction. Now, what did the Supreme Court say when this issue of jurisdiction, based on the flowing from the extrajudicial rendition of Nnamdi Kanu, came before them? They said no, that cannot and should not affect the jurisdiction of the court. At any rate, what an accused person, a defendant, or Nnamdi Kanu can do is to file for fundamental rights, which will take care for the enforcement of his fundamental rights, which is a civil suit that will take care of the excesses of the institutions of government involved. In which case, if the court says yes, and it has been so adjudged that there are issues bordering on extrajudicial rendition, what they will do for him is to award him damages, and then is entitled to apologies. So that takes care of that. But that to say, oh, because that happened, in fact, the Supreme Court said in our own climb, in our own kind of society, if you allow that kind of rule to be put in place, that once there is issue with the pretrial processes, then it means that no criminal, no crime will be solved. The Supreme Court reached that decision, and based on that, they said, okay, go back and then face your trial. Now, another point that was raised by Nnamdi Kanu all through, I think all these issues I'm discussing, he raised them twice. In fact, probably even 3 times. Now, another issue that was raised by him was with respect to the laws under which he was charged. Now, from, let's restrict ourselves to the counts that were sustained. Now, the counts on that charge sheet were all linked to the Terrorism Prevention Act. Now we have 2 of those laws in issue. The first is the Terrorism Prevention Act of 2011, amended in 2013, repealed in 2022. And then you have the 2022 Terrorism Prevention Act, which is the current substantive law on terrorism or terrorist trials. So what was the issue? The issue was, for the defense, their point was that, look, this man was charged under a law that has been repealed. That has been their argument. That is the summary of their argument. And The facts around this are that there was a Terrorism Prevention Act in 2011. That act was amended in 2013. Now, the charges contained here, Kanu was first arrested in 2015. The charges contained here border on activities between that time up to 2021. Now, at the point he was arrested and arraigned, the law, the substantive law bordering and covering his charge, his trial, was the 2013 Act. Now, that 2013 Act, all these other legal gymnastics they did back and forth and everything was under the 2013 Act. Now, the theme challenge to the law, when they were doing their no objections and no case submissions and all of that before the 2022 Act and so on, was that there's a particular count 8, which talks about the unlawful importation of radio transmitters.
Right.
Now, that law was written as Criminal Code Cap C45 or Cap 45 or C45 of Laws of the Federation of Nigeria, 2004. Now, the argument of the defense, the Nnamdi Kanu's team, was that there is no law known as Criminal Code Act law C4 or Cap 45, 2004. But you see, that wrong law had facts surrounding them, which form or established a particular allegation
Against him.
against him. Yes, there were issues of unlawful importation of
Radio transmitters.
And the issue there was that when he imported those things, he declared that the container is housing household items. When in actual fact, the container was housing or housed radio transmitters.
That was the information he supplied to the customs authorities.
To the customs authorities. So in the course of investigation, DSS eventually traced the container, got to, and that was when they brought Benjamin Madu.
The supposed engineer with the telecoms company.
So that was when they brought him in and took his confessional statement. They got the container with the transmitter and then took it in as exhibit. Now, when the Supreme Court was looking at that issue, the court said, yes, this law has been wrongly mentioned, but there is a Cap 45, which is actually the Customs and Excise Management Act, which is the act that actually contains that particular offense. So the court said, well, we cannot say because this law was wrongly mentioned, we will say there is no law in existence that capturing that particular charge. That since there is actually a law that captured those facts, that particular allegation, then he can actually be charged under that law. That was what they said. It's not that the Supreme Court said no because they wrote Criminal Code instead of Customs and Excise Management Act, therefore it is invalid, it is null and void, it should be discharged and acquitted. The Supreme Court never said that, because the thing that gets me marveled with respect to this Kanu's defense team, especially the second to the last set of lawyers that he had, is their unnecessary bid to, I'm sorry to say this, to mislead the members of the public with respect to the facts of the case itself and the real issues to be determined. You see, I had to, for the first time, I had to follow a case of public importance with so much energy. You can imagine me sitting down to read with the whole of our schedules, 144-page documents, trying to read it over and over again, because I really wanted to know what the challenge is. And you see, by the time they went back, they dropped those other charges. In fact, Justice Binta had struck out several of the charges.
Right.
So they were left with just
the 8 of them.
the 8 of them. So now we get back to court. And instead of you to open your defense, you start yelling at the judge, screaming in open court, saying that the judge has refused to keep to the principles in the judgment of the Supreme Court. And I, sincerely speaking, I don't know what decision it was that is in the judgment of the Supreme Court that Nnamdi Kanu kept on sounding to the public as if there is something that is somewhere that our Lordship, Honorable Justice Binta Nyako, didn't want to consider in his favor. All he needed to have done is to open his case, and if there's open his defense, and if there's anything there that he feels, at the point of written address, you bring them up for the court to address
So was
them.
it counterintuitive when he said he wanted to represent himself, firing his
It
entire
was, because
legal team?
when the case now moved from Justice Binta to Justice Omotosho, we had a judge who eventually was determined to ensure that. So it was arraigned first time in March 2025 before Justice Omotosho, and his plea was taken, and the prosecution was put under pressure. The judge had to grant accelerated hearing so that matter would be quickly dispensed. It was almost like a day-to-day thing. In fact, in the judgment, the judge said they had to open morning and afternoon sessions so that they will dispense with
as quickly as possible.
As possible. So he raised his initial issues were that he was not giving adequate materials and facilities for his defense and so on. And then another issue that he raised was still this extrajudicial rendition, and then the issue of the act that was repealed. Now, the point is, in law, it is right that every case will be determined based on the law that was in existence at the time the facts crystallized for that case. So the law that binds this trial is the Terrorism Prevention Act of 2013. Now, the argument is, having rearranged him in 2025, they cannot possibly arraign him under the old law. In fact, as we speak right now, if anybody is investigated with respect to terrorism, and the acts complained of happened before 2013, it will still be tried under the 2013 Act. If it happened before 2022, May, when this current Terrorism Prevention Act commenced, that person will still be tried under the 2013 Act. Because by virtue of Section 98 of the 2022 Terrorism Prevention Act, the law simply provided or provides that whatever happened under the 2013 Act, whatever proceedings, whatever trial, whatever orders, anything at all, whatever decisions, documents, or whatever, will not be affected by virtue of the 2020 Act and shall be deemed to have happened under the 2020 Act with the relevant provisions applying. So that is the scenario. That is what it is.
Just as we try to, I mean, time is limited, but this is getting really interesting. A bit academic and then very, if you like, incisive as well, because this is you trying to lay the facts on the ground the way it is, beyond emotions and sentiments and all of that. But let's wrap up now by looking at what the judge said, stating that, look, ordinarily in the eye of the law, this comes with death penalty, but on humanitarian grounds and all of that. We'll have to scale down a little on the severity of the penalty, exactly, and all of that. What could have been, what could have informed that kind of thinking on the part of Honorable Justice Omotosho?
Well, the judge himself stated the reasons for his decision when he said, well, he's a Christian, he's not God, he cannot take life. He tried his best to allow this young man to. Now, what the judge has simply said is, I won't want to pronounce death on this man. I'll be taking the position of God as a Christian to pronounce death on this man. So I'm giving him life imprisonment. In law, though, he cannot do that. He doesn't have that option.
Well, was that an overreach?
What we'll be looking at is, if Nnamdi Kanu and his team proceeds to the appellate court, and they fail, and of course they will fail.
So those chances are high?
They will fail. The chances are high that they will not succeed at the appellate court, because by refusing to defend himself, he rested his case on the case of the prosecution. In that case, 34 exhibits were tendered against him.
Real
and
time.
Admitted in evidence. So there's nothing speaking against those evidence. And the Supreme Court has held that once you elect in Ajibade and State, once you elect to do that, what you have done is you are telling the court to be free to place reliance on the uncontradicted evidence before the court, which is what happened in this case. So if you go to the appellate court, you are only going to look for technicalities to argue. At any rate, in that judgment, in the judgment of the Federal High Court that convicted and sentenced him, almost 70 to 80% of the judicial decided cases that the judge used, the quotes and everything, the extensive quotes that the judge used, are from cases emanating from Nnamdi Kanu himself between the federal government. Which means the decisions of the Supreme Court were principally the decisions, especially as it has to do with his objection, because he raised another objection again. So now, on the issue of the appeal, personally, I don't see that appeal succeeding.
Doesn't stand a chance.
It doesn't stand a chance. Because there's nothing before that the Court of Appeal will look into. And I don't think there's any technicality that they have to raise. Because all what they could raise, and that the judge was very smart. The court indulged him very, very well.
So he had all his chances.
He had all his chances. Now, for the political solution, yes, it could succeed. But do I also see it succeeding? The issue of pardon and all of that. Do I see it succeeding? I don't think I do, because before that judgment, attempts have been made. People have gone to see the president over and over again. Even people have gone to see them over. Are we going to say that on all of those visits, they never reached any form of decision?
Right.
I think they did. But the issue is, from the body language of Nnamdi Kanu himself, you cannot help him.
I think that's incisive, really. The reference to some of his very unprintable utterances in courts.
Yes.
Most of them are
No remorse.
quite,
You can't help him.
Yes, out there in the media. But again, I think this is a conversation you and I will have to have as we make progress, especially from the standpoint of this appeal that we understand is going to start. It's already started. Explore as it stands right now. I'd like to say a big thank you to you for coming on the program. I've been talking with Barrister Monday AJ just to look at the outcome of these judgments regarding Nnamdi Kanu, the leader of the proscribed IPOB. We'll continue to monitor the situation as it unfolds. I'm Uyag Mofwegbe. On behalf of my team here producing this program, we'll say thank you for watching, and our broadcast continues on Global Television.